Very good evening everyone. Welcome to BAJIRAO IAS Academy, the Hindu News Analysis. Today is 30th August 2025 and today we have some important topics from the Hindu newspaper. One by one, we'll be discussing all these important topics in a very detailed and in-depth manner. And in fact, there are a set of topics and those topics are important for prelims and mains examination. So let's look into some topics which are important for the mains exam. So the first topic with which we are going to start this session is about the unemployment problem in India. So let's understand all the facets of job creation in India. Now this article has been given in the Hindu newspaper and this could be important for the General Studies Paper 3 Economy paper. What is the context? In which context this topic has been given in the newspaper? So let's understand the context first. So the context is that on July 1st 2025 the Union government has approved the employment linked incentive scheme. And in fact, the employment linked incentive scheme has been launched by the Union government to promote employment in India. And in fact, the total outlay for the employment linked incentive scheme is rupees 99,446 crore, which is a huge amount to create employment in India. And it focuses on generating gainful employment opportunities for India's youth. However, this scheme reflects the overall commitment of the government addressing India's persistent labor market challenges. However, its design and focus raise some critical questions. And in this particular article, we'll be discussing what are the critical concerns which are associated with the employment linked incentive scheme. And in fact, if you look at India's labor market, it is being marked by a deep capital labor asymmetries. For example, if you look into Indian labor market, so most of the industries are either capital intensive industries or the technology intensive industries. So therefore, it requires a less labor force, right? So there is a need for the labor intensive industries. They can create gainful employment opportunities. And apart from that, there is a divide which is existing between formal and informal sector as well. And in fact, a chronic mismatch between the employment opportunities and the employability in India. However, this employment linked incentive scheme would further reinforce the existing inequalities rather than resolving them. So any program which aimed at creating gainful employment opportunities should actually look at these labor market problems or the concerns rather than reinforcing existing inequalities. So I hope you have understood the context of this topic. Now let's understand the employer-centric design of the employment linked incentive scheme and the labor market mismatch which is existing in India. And in fact, it is being said that the employment linked incentive scheme adopts employer-centric approach rather than the employee-centric approach. Now employee-centric approach will benefit the employees more rather than the employer-centric approach such as the employment linked incentive scheme. And in fact, the employment incentive scheme also provides fiscal incentives to the employers, particularly in the manufacturing sector, to create jobs. In India, the manufacturing sector have the potential to create large-scale and gainful employment opportunities for India's youth. So therefore, the employment linked incentive scheme primarily targets the manufacturing sector. However, this strategy overlooks the structural issue of skill mismatch. Now, what is skill mismatch? The skills which are required for the industry. And this is what is called as skill mismatch. The youth who are looking for the jobs, they lack the skills which are required for the industry. So this is what is called as the skill mismatch. However, the Economic Survey 2024 and 25 reveals that only 8.25% of graduates secure jobs aligned with their qualifications. And in fact, over half are unemployed in semi-skilled or elementary roles. Consequently, wage data also highlights the disparity existing, as nearly 46% of India's graduates are in low skill jobs earn less than 1 lakh per annum. However, only 4.2% of specialized positions reach 4 to 8 lakh per annum. And in fact, just 4.9% of India's youth are receiving formal vocational training. Industry demand, workforce preparedness remain deeply misaligned in India. However, in this context, subsidizing the employers to hire an underskilled workforce does little to enhance productivity or worker well-being as well. So therefore, the employment linked incentive scheme is mostly the employer centric approach or employer centric scheme. And instead, the employment linked incentive scheme risks further strengthening employers' bargaining power, and it further widens the wage gaps, perpetuating a cycle of low skill, low wage employment as well. So these are some potential risks which are associated with the employer centric design of the employment linked incentive scheme in India. So let's understand some concerns surrounding employment linked incentive scheme. And through this employment linked incentive scheme, there is a possibility of exclusion of the informal sector, because the scheme has been relying on employees' provident fund organization registration and thereby effectively limiting its benefits to the formal sector, thereby further excluding 90% of the workforce employed informally. And in fact, this exclusion not only sidelines workers without social security and formal contracts, but it also further entrenches the dual labor market, one where a state invests heavily in formal sector while leaving the informal sector unsupported. And in fact, in such a policy orientation, it particularly channels the public resources towards certain enterprises which are already better positioned, and marginalizing low wage, unregistered workers who absorb most new labor market entrants. And in fact, the employment linked incentive scheme further leads to the marginalization of women and youth as well, because this scheme's emphasis on the manufacturing sector reflects an outdated assumption about its job creating potential. It is true that in India, manufacturing sector is considered as a labor intensive sector, so therefore it has the probability or it has the potential to create gainful employment opportunities for the youth. So therefore, it is being said that it is an outdated assumption. So in fact, if we say that the manufacturing sector can create gainful employment opportunities, it is an outdated assumption. And in fact, the employment linked incentive scheme also heavily depends on the manufacturing sector and its potential to create jobs. However, manufacturing sector now accounts for less than 13% of the total employment. And in fact, the agriculture and services together contributing to around 70% of the total workforce. So therefore, more than manufacturing sector, service sector and agriculture sector are the largest contributors of the workforce in India. So therefore, the employment linked incentive scheme is merely focusing on the potential of the manufacturing sector to create gainful employment opportunities, and they are neglecting the service sector and the agriculture sector in the job creation. So therefore, this is a flawed approach on the part of the employment linked incentive scheme. So therefore, what should be the way forward in this context? However, even though there are certain fundamental flaws within the employment linked incentive scheme, but it is true that it signals the political will from the government to tackle unemployment. So it shows the government remains committed to tackle unemployment. However, the current design of the employment linked incentive scheme risks further deepening the structural inequalities which are existing in India's labor market. So therefore, there is a need for a better and more effective approach, and such an approach would further integrate robust skill development and education reforms. And in fact, it would further ensure that the low skilled workers can meet industry needs and they can also access better quality jobs. And similarly, the policy emphasis should shift from short-term headcount increases to long-term strategies. They can sustain employment, enhance productivity, and further strengthen the labor market rights as well. So therefore, there is an appropriate way forward, and that focuses on addressing the existing inequalities in India's labor market rather than reinforcing the inequalities. So therefore, there is a need for a comprehensive employment-linked incentive scheme that could address this potential problem and that could address the skill mismatch as well. So therefore, we can use the existing demographic dividend in a more efficient and effective manner in India. And in fact, if I talk about the employment linked incentive scheme, so this employment linked incentive scheme aims to incentivize the creation of more than 3.5 crore jobs in 2 years. And in fact, the benefits of the scheme would be applicable to jobs created between 1st August 2025 and 31st July 2027. And as per the employment linked incentive scheme, the first time employees will get 1 month's wage up to 15,000 rupees from the government. So I hope you have understood this topic. And the next topic is, in Lok Sabha, Speaker moves a motion to remove High Court judge. And the process has started to remove High Court judge. Now we'll understand how a High Court judge is being removed, or how a Supreme Court judge is also removed through a comprehensive process. And remember, this is very important for both prelims and mains examination, right? So in fact, it is a very complex process, and removing a High Court judge is also not easy. So we'll understand what are the reasons that led to the removal of the judges. Now, in fact, the Lok Sabha Speaker, Mr. Om Birla, admitted the removal motion against Justice Yashwant Verma of Allahabad High Court. And in fact, he also constituted a 3-member inquiry committee to probe corruption charges after the burnt currency notes were found at his residence. And in fact, the process for the removal of a High Court judge or a Supreme Court judge is based on the Judges Enquiry Act of 1968. And in fact, the Judges Enquiry Act of 1968 has clearly provided for the process to remove judges of the Supreme Court and High Court. Now, what is the reason for the removal of the Justice Yashwant Verma of Allahabad High Court? Because a burnt currency notes were found at its residence. So therefore, if you can look into the background of this case and the removal process. Now the accused judge, Justice Yashwant Verma, so who is from Allahabad High Court. Now in fact, he was earlier served in the Delhi High Court as well. So what was the allegation against Justice Yashwant Verma? The allegation was burnt cash or currency notes were found at his residence in Delhi on March 14. So initially there was an in-house probe by the Supreme Court. And in fact, the Supreme Court inquiry initially indicated corruption charges against him. And in fact, after this initial probe, the Supreme Court has asked Justice Yashwant Verma to resign, otherwise ready to face the impeachment. However, Justice Yashwant Verma refused to resign, so therefore the Supreme Court has recommended the impeachment of Justice Yashwant Verma. And consequently, a motion has been passed in the Lok Sabha, and this motion was signed by 146 MPs. And in fact, the Speaker of the Lok Sabha has also constituted a 3-member inquiry committee and that was formed under Section 3, Subclause 2 of the Judges Enquiry Act of 1968. Remember, as I have already told you, that the Judges Enquiry Act 1968 provides for the procedure or the process to remove the judges of the High Court and the Supreme Court. And the panel members of the 3-member enquiry panel, including Justice Arvind Kumar, Supreme Court Judge, Justice Manindra Mohan Srivatsava, Chief Justice, Madras High Court, V. Acharya, Senior Advocate, Karnataka High Court. Right, so this is the brief background and the removal process of Justice Yashwant Verma. Now let's understand some key constitutional and legal provisions with respect to the removal of the judges of the Supreme Court and High Court. So there are certain articles which specifically involved here. Article 124 Clause 4 of the Indian Constitution. It talks about the procedure for the removal of the Supreme Court judges, and it also applies for the judges of the High Court as well. So therefore, just remember, Article 124 Clause 4 deals about the procedure for the removal of the judges of the Supreme Court, and Article 217 talks about the procedure for the removal of the judges of the High Court. Similarly, Article 217, it talks about the conditions for the appointment and removal of the High Court judges. And Article 218, it talks about the application of removal provisions to High Court judges. Remember, I've told you that the Judges Enquiry Act of 1968, it provides for the detailed procedure for the removal of the judges of the Supreme Court and High Court. So therefore, it requires the parliamentary motion supported by the requisite members, and then it will be followed by the Enquiry Committee report. Firstly, a motion has to be adopted by either House of the Parliament. In case if this motion is passed or moved in the Lok Sabha, then if it is approved by the required number of members, then the Speaker of the Lok Sabha will constitute a 3-member panel to inquire into the allegations against a judge. So if those allegations are proved correct, then the Lok Sabha Speaker would initiate a motion or a resolution. Then that has to be passed by a special majority by both houses of the parliament. Then it will be addressed to the president. Then the judge will stand impeached or removed. And if we talk about the grounds for the removal of the judges, the grounds including proven misbehavior and incapacity. So these are the 2 grounds for the removal of the judges of the Supreme Court and High Court. However, if we talk about the removal of the president, violation of the constitution is the ground for the removal of the or impeachment of the president. And if we talk about the impeachment process, after a detailed inquiry conducted, a motion must be passed by each house of the parliament with a special majority. Right? So this is how the judges of the Supreme Court and High Court are being removed. So next, a very important article is recently the Bombay High Court has clearly held that Aadhaar, voter ID are not proof of citizenship. Now, in what context the Mumbai High Court has given this judgment? So let's understand this, and this could be very important for prelims and mains examination as well. Now, what is the context? So the context is that the Bombay High Court has recently rejected the bail plea of an alleged Bangladeshi national who is staying illegally in India. And in fact, the Bombay High Court has also said that Aadhaar, PAN card or voter ID are not conclusive proof of Indian citizenship under the Citizenship Act of 1955. We all knew that the Citizenship Act has been passed in the year 1955. And the Bombay High Court has clearly mentioned that the Aadhaar card, PAN or voter ID are not the proof of citizenship in India as per the Citizenship Act of 1955. So let's understand the background and the court observations in this matter. So there was a person called Babu Abdul Rauf Sardar, and he was arrested in Thane in the year 2023 for illegal entry into India from Bangladesh. And once he entered into India illegally, he obtained identity documents such as Aadhaar, PAN, voter ID. And he used forged papers to acquire these identity documents. However, the defense argument was he claimed to be an Indian citizen since 2000 2013. And in fact, this person argued that he claimed to be an Indian citizen since 2013. And he also have Aadhaar, PAN card, voter ID and valid passport as well, which are being linked to income tax and bank accounts in India. However, Justice Amit Borkar had clarified that these documents serve identification purposes, but they are not the proof of citizenship in India as per the Citizenship Act of 1955. Bombay High Court has held this. However, the police have recovered Bangladeshi birth certificate from this Babu Abdul Rauf Sardar, and in fact from his phone call records showing frequent contact with his Bangladeshi residents as well. So this establishes a clear and conclusive proof that Babu Abdul Rauf Sardar, he's illegally entered into India from Bangladesh, and he also obtained Aadhaar, PAN, voter ID through forged documents. And in fact, citing the national security concerns and ongoing investigation, the Bombay High Court found it improper to grant bail at this stage to this individual. And this is the brief background and court observations in this matter. So let's understand the legal and national security significance of this issue. And this judgment from the Bombay High Court stating that Aadhaar, voter ID, PAN are not the proof of citizenship as per the Citizenship Act of 1955. So this judgment reinforces the citizenship claims must be backed by legal verification, not just possession of ID cards. Secondly, it further strengthens the distinction between government issued IDs and citizenship certificates. Third, it also ensures illegal migrants cannot exploit the ID systems for the legitimacy. So therefore, it actually set a strong precedent for the illegal entered other nationals into India. Now, in fact, if we talk about key points with respect to citizenship proof, the Citizenship Act of 1955, it says it is actually the primary law governing citizenship acquisition in India. And if we talk about modes of acquisition of citizenship, it includes by citizenship by birth, descent, registration, naturalization, and incorporation of the territory. So these are the modes of acquisition of citizenship. And if we talk about the identity versus citizenship, documents like Aadhaar, PAN card, voter ID, so they only establish identity and not the citizenship. Right? So this is how the Bombay High Court has ruled with respect to the citizenship and proofs that are required to prove the citizenship. So next important topic is a two-language policy that has been recently adopted by the Karnataka government. So let's understand the context first. The context is that Karnataka state education policy. So it has recently proposed a two-language policy. And a two-language policy has been proposed for 90% of the schools, replacing the three-language formula that included Hindi. So if we generally say three-language formula, it generally consists of a regional language, English along with the Hindi, which is considered as a three-language formula that has been recommended by the National Education Policy. However, recently, the Karnataka State Education Policy Commission has adopted a two-language policy, and this two-language policy consisting of a regional language along with English excluding Hindi. However, this change aligns with the broader national education policy discussions on the language instruction. However, according to Karnataka State Education Policy Commission, this two-language policy applies to government schools, aided schools, private schools which are offering Kannada or English as a medium of instruction, with certain exceptions for the linguistic minority institutions as well. So let's understand some key recommendations of the State Education Policy Commission of Karnataka. So it says the two-language policy will be applicable to all government schools in Karnataka along with aided schools, private schools which are using Kannada and English as a medium of instruction. And in fact, a 90% coverage across state's education system, impacting both primary education and secondary education as well. So effectively, the two-language formula would cover around 90% of the state education system. However, the minority schools such as Urdu schools, Marathi, Tamil, Telugu, Malayalam schools, they can retain the option to teach 3 languages promoting linguistic diversity. Now, what is the 3 language formula here? So along with Kannada and their mother tongue, along with that English also. So therefore, the minority schools would have the option to teach 3 languages to promote the linguistic diversity, but not Hindi. And in fact, the mother tongue of students to be preserved in minority schools. For example, if there is a minority school which is based on Telugu, right? So Telugu speaking people are a minority in Karnataka and they have a school. So in order to preserve the minority schools, their language, there might be a 3 language formula for those minority schools so that they can protect their mother tongue along with Kannada and English. And third language in minority institutions remains optional for learning purposes, moving away from the mandatory Hindi imposition. So let's understand the language policy in education. So if I say 2 language policy, it includes Kannada and English taught as a first, and English will be taught as a second language in most schools. And if I say the 3 language formula, earlier it has included Hindi, but now it was dropped for majority schools, thereby it becomes a 2 language formula. There are certain minority language schools also, they continue with Kannada, English and their mother tongue. A mother tongue might be Telugu, Malayalam, Tamil, Urdu. And in fact, there is an optional third language for the minority educational institutions, and it will not be counted for the assessment of the students. And if we talk about the assessment norms, only Kannada and English are considered for the exams in most of the schools, including the minority schools as well. So therefore, this new policy aims to balance the need for strong regional language skills with English proficiency while respecting the linguistic diversity and also promoting the value education through a more focused curriculum. Right? I hope you have understood this topic, and that's all in this lecture, and thank you so much. If you like our class, please subscribe our YouTube channel and also hit the like button. Thank you.